Hello lovely people, I'm sure you're enjoying our videos. As you've realized, our videos are in two parts. We've got the course-based ones that discusses the various sections of the law, and we've also got the everyday law. The course-based are designed for academic study and in-depth understanding of the law. But if you are interested in knowing about the law as it will appear or it will be useful for an everyday man, please always try and keep a focus on the everyday law content. It is done in vernacular and in simple and easy way said that the man on the street will be able to appreciate the law in his daily life. If you stand in need of any academic support for any of your law courses, please do not hesitate to reach the number below, either via call or by WhatsApp. Stay tuned for more of our videos on Supreme Law Publications. Hello, friends, students, colleagues, you're welcome to our continuing videos on under Ghana legal system. And as you've realized, we've been focusing on the jurisdiction of the Supreme Court. In the first part, or the earlier parts that you saw in the video, we discussed the Supreme Court's general jurisdiction. In part two of our discussions on the jurisdiction of the Supreme Court, we are going to discuss, I think, the most contested, most famous aspect of the Supreme Court's jurisdiction. It is a part that every student or constitutional law student and a student of the law ought to appreciate and clearly understand. And it's most examinable. So for the students, if you are looking at the jurisdiction of the Supreme Court in pursuant to further preparations for your exam, this particular jurisdiction that we are going to talk about in this video is of utmost importance for your studies. And we are saying that it is the Supreme Court's exclusive original jurisdiction. That is the jurisdiction of the Supreme Court, grounded under Article 130 of the Constitution. Now, in this video, this is how our discussion is going to be. First, we are going to look at the background to that particular 130, the Article 130 jurisdiction, or the exclusive original jurisdiction. So we'll try and discuss the constitutional preambles that lead us to Article 130. Then, secondly, we'll come and do an examination of Article 130 itself. What are its components and what exactly do they mean in light of judicial pronouncements as to what the jurisdiction of the Supreme Court is, as explained in there. Then we'll also explain some other allied or other associated issues with reference to that. So, hope you are clear, we are set. Now let's move on in our analysis. First, we'll try and see the constitutional preamble or background to the jurisdiction of the Supreme Court, which is known as the exclusive original jurisdiction, mentioned under Article 130. Okay, now see, you know the Constitution, as we've already seen, if you've watched our videos on constitutional law, you see that we've explained that the Constitution is more of like the backbone of the actors or the backbone to the acts of state institutions. That is how the powers of government is run. It's clearly founded in the Constitution. The Constitution itself mentions under Article 1, Clause 2. Let's see Article 1, Clause 2 of the 1992 Constitution. Article 1, Clause 2. This Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution, to the extent of the inconsistency, be void. You saw what was mentioned under Article 1, 2. The Constitution itself delivers of itself that the Constitution shall be the supreme law of Ghana. It should be the fundamental law of the land. Any other law that is found to be inconsistent with the Constitution or any provision of the Constitution, to the extent of that inconsistency, is void. What we mean is that there cannot be any other law here in Ghana that should be bigger than the Constitution. That is what we mean by saying the Constitution is the supreme law of the land. That being said, it helps us to understand that when you take the Constitution and its provisions, that is the highest. That is the highest law, the supreme law of the land. So you see, if there is going to be a situation where someone has got issues, or there are certain particular actions, statements, or conduct of persons, where these particular conducts of these persons are against the highest law of the land, then we need to have a kind of body, or we need to take it to somebody, either a natural person or any kind of, any constituted body, that will also be given such kind of high powers, such that they will be able to give effect to those particular breaches of the supreme law of the land. I'm sure that is logic. Okay, so you have the highest law of the land. If the highest law of the land is breached, then someone with an equally higher level of authority should be in the position to deal with those particular breaches. It is clear. So pursuant to this kind of logic, the Constitution also proceeds under Article 2 to give us some bit of more information there. Let's see under Article 2 of the 1922 Constitution. Article 2. Article 2, Clause 1. A person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment, or B, any act or omission of any person, is inconsistent with or is in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. Did you see what the Article 2 of the 1922 Constitution further mentions? So the Constitution has said, and you can see the progression, the Constitution is the supreme law of the land. Any other law that is inconsistent with the Supreme Court to the level of that inconsistency is void. Article 2 also continues, therefore, to say that if there is a person, obviously a citizen of Ghana, who alleges that someone has done a particular action, be it a state, be it an institution, or the person alleges that there's a certain enactment, there's a certain act of parliament, a certain other law that parliament has created, and this particular law is inconsistent with the Constitution or the constitutional provisions, the spirit in there does not agree with the Constitution, the person should bring an action to the Supreme Court for a declaration to that effect. So by logical inference, it therefore means that when the supreme law of the land is broken, or when the supreme law of the land is compromised, there has to be a corresponding higher level authority whose duty or constitutional responsibility will be to deal with those particular kind of constitutional infractions. So the question is, just from Article 2, which particular body do you think has got that right or has got the constitutional responsibility to deal with infractions or encroachment onto constitutional provisions? It is obvious. It is the Supreme Court. So guys, the point is this. The background to the jurisdiction of the Supreme Court under Article 130 is premised both on the letter and spirit of Article 1, Clause 2, and also Article 2, particularly Article 2, that if anyone alleges that there's an action or omission or the kind of variations or statements that are made under Article 1 or 2, the person is free to bring an action to the Supreme Court for a declaration to that effect. That sets the ball rolling or sets the tone for the Supreme Court's exclusive original jurisdiction under Article 130. So now that we understand the constitutional premise, the constitutional background under Article 1 and Article 2, under which the Supreme Court is the highest authority to deal with matters involving the Constitution, let's just quickly delve into the jurisdiction of the Supreme Court's exclusive, the Supreme Court's exclusive original jurisdiction under Article 132. Again, we move to Article 130 of the 1992 Constitution. Article 130. Article 130, Clause 1. Subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms, as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in A, all matters relating to the enforcement or interpretation of this Constitution. Did you see under Article 130, Clause 1A? Now, what I'm trying to do here is that we are trying to break down Article 130, all right? So we take Article 130, Clause 1 and the A part. What were some of the essential points or the salient points that you found from the Constitution? Now, from your copy of the Constitution, you saw a couple of things. It mentions under Article 130 that, Clause 1, that subject to the jurisdiction of the High Court, okay, the High Court's jurisdiction to deal with matters that involve the enforcement of the fundamental rights of humans and freedoms, as enshrined in Chapter 5 of the Constitution, the Supreme Court shall have, and it mentions, an exclusive original jurisdiction in the enforcement and interpretation of matters relative to the particular Constitution. So now, what are the key points that we can glean from this? This is what it therefore means. Now, there is the thought of one, exclusive original jurisdiction. Exclusive original jurisdiction. What exactly do we mean by that? So, and when you mention Article 130, guys, the point is that the jurisdiction of the Supreme Court, which we call the exclusive original jurisdiction, is what is founded in Article 130. What it means is that the Supreme Court will have the power to hear certain matters for the very first time. Okay, for the very first time. Which means that when there are certain kinds of issues, and these issues surround the Constitution, like encroachment or breaches of constitutional provisions, either by its letter or by the spirit. When I say by the spirit, what we are trying to mean is that if there are certain particular actions or omissions that we've already identified, and these acts or omissions contravene kind of the general purpose of certain provisions or class of provisions in the Constitution, we say that it is affecting the spirit of the Constitution. You understand that? The Supreme Court's exclusive original jurisdiction means that the only court that has the power to hear that matter for the very first time. You understand that? That is what we mean by the original jurisdiction. Someone can bypass all courts and bring the matter to the Supreme Court for the very first time on this hearing. That is what we mean by an original jurisdiction. Original, the earliest, its first time. Someone can do that. And we are saying that that is what we mean by the exclusive original jurisdiction. The Supreme Court will have that power, okay, or its jurisdiction to hear for the very first time matters that pertain to enforcement and interpretation of any provision within the Constitution. So, if there is an issue, that issue borders on a constitutional provision, and we think that that constitutional provision is being infringed, generally, or the constitutional provision is that the Supreme Court's jurisdiction is exclusive original jurisdiction. Exclusive because it is unique to the Supreme Court. No other court will have the power to entertain that particular action or would have the right to take that issue if it is not the Supreme Court. You understand that? If it has got to do with an enforcement and an interpretation of a provision within the Constitution. Later, I'll come down and break down to you some of the criteria or the indicia that will qualify a matter to be brought before the Supreme Court if it borders on interpretation. We'll come to that shortly. But what we want to get in essence is that when we talk about the Supreme Court's exclusive original jurisdiction, we are saying that the Supreme Court's jurisdiction, its power, okay, its constitutional mandate to hear a matter on first time is one, premised on enforcement issues and interpretation. And it is exclusive to the Supreme Court. So now, we'll try and take in a very one of the Supreme Court's decisions, and this case was entitled Samuel Osei-Boateng versus the NMC and another. Now, in that particular matter, Justice William Atuguba, in trying to explain or give effect to the Supreme Court's position on how it takes or it construes matters when it refers to its exclusive original jurisdiction, gave a very explosive judgment. And this is what he had to say in the case of Samuel Osei-Boateng and the NMC by William Atuguba. By Atuguba, Justice of the Supreme Court, as he then was. No court other than the Supreme Court has jurisdiction to entertain an action to enforce any article of the Constitution, even if its clarity is brighter than the strongest light. The learned justice continues. However, when an enforcement issue coincidentally arises in any court, and the article involved is crystal clear, such courts may apply the Constitution to it. Guys, you understand that. You saw what Justice Atuguba, speaking for the Supreme Court at the time, in one of his statements made in the Samuel Osei-Boateng case. The point is very simple. This is consistent with the Article 130 that if there is a matter and it involves the enforcement of the Constitution, it involves an interpretation of a contentious aspect or a seemingly contentious aspect of the Constitution or a provision of it, the only court that has the power to hear that matter for the first time, you can't take it anywhere, to hear it for the very first time, that's what we mean by original jurisdiction. It is the Supreme Court, and that jurisdiction is exclusive to the Supreme Court. You understand that? So we are saying that it is exclusive original jurisdiction when it has got to do with an enforcement of the provisions of the Constitution or an interpretation of the constitutional provisions. So any particular action that has got that, the Supreme Court can be prayed to deal with it. So you see, if you take, for example, here in Ghana, like following this particular provision of the Constitution, there has been several cases in which the Supreme Court's enforcement jurisdiction or the Supreme Court's exclusive original jurisdiction has sought to be invoked by persons who claim that actions by other authorities or bodies were in contravention of the Constitution. A famous one that I want to bring your attention to is the reputed case of Agbevo versus Attorney General. I'm sure you might have heard that particular case. A brief facts or background to the Agbevo case is this. You know, Agbevo was a judicial secretary, okay? A judicial secretary who was appointed pursuant to the provisions of the 1992 Constitution to serve in a particular capacity. Along the line, he received a notice or a dismissal letter from the presidency authorizing that he, Agbevo, should hand over, and therefore he had been dismissed. He challenged this decision of the presidency and brought an action at the Supreme Court against the government through the Attorney General, obviously, seeking to invoke the Supreme Court's original jurisdiction pursuant to Article 130 to say that as a judicial secretary, his appointment is not done by the president, and therefore the action of the presidency in trying to dismiss him was in contravention with the letter and spirit of the Constitution. Now, when the Supreme Court listened to the matter, a preliminary issue that had to be determined was whether the matters that Agbevo was alleging was properly founded on the Supreme Court's original jurisdiction. What do you think? The Supreme Court found that yes, it is true, because the Supreme Court has got the right to enforce any aspect of the Constitution or a provision of the Constitution that a plaintiff or an applicant alleges is being breached. So to the extent that the Constitution has placed the judicial secretary under the exclusive constitutional custody of the Chief Justice, and the presidency was writing a letter to dismiss him, the Supreme Court found that that particular action was unconstitutional. So the original jurisdiction was properly invoked. The Supreme Court heard the matter, and they make sure that the law was rightly settled. So this, again, fits into the aspect where we are saying that when we have an enforcement issue of a provision of the Constitution, and also involves an interpretation, the Supreme Court's original jurisdiction will be properly invoked. And we are saying that it is exclusive to the Supreme Court. It's only the Supreme Court that has the power to hear the matter as a court of first instance. We hope you're clear with that. All right, that is fine. Now, let me just touch a bit on the other aspect of interpretation. Okay, so you will see that we are saying that the Supreme Court also has got the exclusive original jurisdiction in all matters involving interpretation and enforcement, okay, or enforcement and interpretation. Some literature, or in some places, you may hear it being said that it is the interpretative jurisdiction of the Supreme Court, the Supreme Court's power, okay, to interpret the Constitution. What do we mean by that? Now, in the locus classicus case, when we say locus classicus case, it means that it is a case that we will have to primarily refer to any time we talk about the Supreme Court's interpretative jurisdiction, the power of the Supreme Court to interpret the Constitution. This case is also sometimes affectionately called the Enin Doctrine. Why? Because it was delivered by one of Ghana's finest justices, Justice Enin at the time. The case is the Republic versus Special Tribunal, ex parte Akosa. Now, that was reported somewhere around 1980 in the Ghana Law Reports. Now, if you read that particular case, it has always been the foundation stone for the interpretative jurisdiction, the compass of the interpretative jurisdiction of the Supreme Court. Amongst other considerations that were given in that ex parte Akosa case is that if the interpretative jurisdiction of the Supreme Court is being sought to be invoked, or an action is being brought to the Supreme Court seeking an interpretation of the Constitution, a lot of things or some considerations are to be given. One of them is that that particular provision that a person is alleging or seeking to invoke the Supreme Court's interpretative jurisdiction, it should be a provision that the person will be able to show that it is imprecise, it is ambiguous, or it lacks some kind of clarity. Okay, again, if it is imprecise, it is ambiguous, or it lacks some kind of clarity. That is, the clarity of it is difficult to determine. There is some kind of ambiguity such that you cannot try and in one breath it may mean that, in another breath it may mean something else. When that particular ground is satisfied, the interpretative jurisdiction of the Supreme Court can be invoked, such that if the matter is clear, the authorities are to the effect that it may not really give rise to a matter of interpretation, and therefore the Supreme Court's jurisdiction may not be properly invoked in that particular side. The other aspect of the Enin case or the Republic versus Akosa case is that if there are rival interpretations such that the authorities that is granted to certain bodies under the Constitution, let's say you have an agency A, another agency B, or another group A, another group B, both bodies that are guaranteed under the Constitution. And maybe because of the constitutional mandate given to A and B, there seems to be some kind of dichotomy. There seems to be some kind of conflict in between the constitutional rules that has to be played by one of the bodies and the other constitutional rule that has to be played by the other body. And there's that kind of rival interpretation. The ex parte Akusa case says that it may raise a matter of what? Interpretation. And when that happens, okay, when that particular thing happens, we are saying that the Supreme Court's exclusive original jurisdiction can be brought to bear. Why? To interpret that particular aspect of the Constitution. Hope you are fine. So that is what we mean by that. Now, just to add to this, I want to draw your attention to a very famous case. It is Bimpombuta versus the Ghana Legal Council. And in there, this is what the court had to say relative to this matter of interpretations. By court, regardless of the manner in which they are clothed, where the real issues arising from a writ brought under Articles 2 or 131 of the Constitution 1932 are not in actuality of such character as to be determinable exclusively by the Supreme Court, but rather fall within the course of action cognizable by any other court or tribunal of competent jurisdiction, this court will decline jurisdiction. You saw that. So guys, the point is clear. If we talk about the Supreme Court's exclusive original jurisdiction, as we've mentioned, by the authorities that has been stated, for example, in the Bimpombuta case, we are saying that when someone is coming under Article 2, 131, the object is very simple. If it is an interpretation, it is an interpretation matter that has been raised relative to its inconsistency with the letter and spirit of the Constitution. Once that thing can be clearly shown, the Supreme Court becomes a proper forum for such remedies to be sought. That is what we mean by the exclusive original jurisdiction of the Supreme Court for both enforcement and interpretation. And we've mentioned the special tribunal case, ex parte Akusa, to say that if rival meanings are put on some particular meanings of Supreme Court, said that there is imprecision, ambiguity, the Supreme Court could be the forum, or should be the forum, or the constitutionally mandated body to deal with that particular interpretation aspect. Said that clarity could be brought to the understanding of that. Hope you get it. All right, so that's the first point. We've tried to explain what we mean by the exclusive original jurisdiction of the Supreme Court. Now, second, to Article 131, there is something in there. You will notice that in the first part of the Article 130, it mentions that subject to the jurisdiction of the High Court in the enforcement of fundamental human rights and freedoms under Chapter 5 of the Constitution. Then the Supreme Court jurisdiction comes up. The question has always been on the minds, lingering, through students and the minds of lawyers, and also at the court alike, that what exactly is the scope or limits or the framework under which we talk about this subject to the jurisdiction of the High Court? What does that mean? The position has always been by many that initially the thought was that when we say subject to the jurisdiction of the High Court, you know, the Constitution under Article 33 mentions that if there is a High Court, if there is an infringement of someone's fundamental human rights, I mean, the person's right to life, the right to property, his right to privacy, those other matters that are enshrined under Chapter 5. By virtue of Article 33 of the Constitution, a person who is aggrieved that his human rights is being breached has to go to the High Court to seek an enforcement of that. The question has arisen that, okay, does that mean that the Supreme Court has not got a hand if there are human rights issues? So if someone has a human rights problem or there's a human rights issue that arises in a particular matter, under no circumstances will the Supreme Court have the right or the jurisdiction to hear that matter. What exactly do you mean by subject to the jurisdiction of the High Court on enforcement of fundamental human rights? Okay, so again, we'll refer to the case of the Samuel Boateng case of the National Media Commission. Now, a bit of the background to this. You know, the applicant had sought to invoke the Supreme Court's original jurisdiction under Article 130, seeking to show that if you take, for example, a part of the Constitution, a very famous one, Article 296, that says that administrative bodies should act with discretion according to rule of law. Okay? Osei Boateng's complaint was that the National Media Commission had unilaterally appointed someone to be a director of, I think, the Ghana Broadcasting Corporation or one of the state broadcasting agencies without giving all Ghanaians the opportunity to apply for the job. So he felt that that was in breach of the letter and spirit of the Constitution because it had denied people, okay, their human rights or the right to work amongst other fundamental human rights. And when you go to, for example, Article 23, it mentions that administrative bodies should act with, due discretion and all that. So some of Osei-Boateng's case was that particular step that the NMC had taken, where they had just appointed somebody without giving Ghanaians the opportunity to apply, was something that was in breach of the human rights of Ghanaians. But the matter went to court, and the court had to look at it and determine whether or not the Supreme Court's original jurisdiction had properly been invoked. Was it a human rights matter that was the preserve of the High Court, or it was a human rights matter, but still the Supreme Court could enter in there? Now, in that particular matter, Justice Samuel Kofi Dateba, Justice of the Supreme Court, who wrote the lead judgment, had this to say that brought a bit of clarity into what we mean as to the circumstances under which the Supreme Court could also deal with matters that involve human rights. This is what Justice Samuel Dateba said in the case. By court, Dateba. Thus, even if the plaintiff were relying on Article 23 alone, this court will still have jurisdiction because he will be relying on Article 23, not in his own personal interest, but in order to test the constitutionality of the defendant's action in the public interest. Hope that is clear. So the Supreme Court has said, as you saw in the statement by the learned Justice Samuel Kofi Dateba, Justice of the Supreme Court speaking at the time, that if you have a human rights matter and the nature of the human rights matter that is being alleged, it is a breach that substantially affects the public, or it's a matter that is in the interest of the public, then it does not just become a matter that is of personal interest. It is a matter that is of public interest, and therefore the Supreme Court can assume jurisdiction in there. Hope you're okay. So this is the point. When there is a fundamental human rights issue, or there is a breach of someone's fundamental human rights, and it is regard to the person, the Supreme Court or the Constitution's meaning, or the meaning of Article 130 in there is saying that those matters are for the Human Rights Court. So go to the High Court and have that matter dealt with, because it is in reference to a person's breach, or it is in reference to an allegation of a person's human rights being breached by as an individual. However, if the breach of the human rights or the alleged breaches that we are speaking about, it is in the interest of the public, it is public in nature and character, okay, by the very nature of the breaches that is going on, it is of a public interest, it affects the wider Ghanaian public, then it becomes more of a constitutional matter, right? And hence, the Supreme Court's exclusive original jurisdiction can be invoked. So the Supreme Court will have jurisdiction over all human rights matters if that particular human rights breach that is being alleged is public in nature. That is the end of the story. Hope you understand that. But if it is personal in nature, the person has to go to the High Court. But if it is of public interest, and therefore a person is seeking to bring an action at the Supreme Court will have its original jurisdiction being properly invoked. That is what we mean by the exclusive original jurisdiction of the Supreme Court on human rights matters, subject to the rights that the High Court will have, or the jurisdiction of the High Court to hear those particular ones. I think we're okay with that, all right? Okay, so now having set with Article 131A done, let's go to Article 130B and see what the Constitution also says relative to the jurisdiction of the Supreme Court. Article 131B. Continuing on the Supreme Court's exclusive original jurisdiction, 131B says that all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or on any other authority or person by law or under this Constitution. So you saw under Article 131B, again it mentions this Supreme Court's exclusive original jurisdiction. It continues saying that if there is an act of Parliament or any other authority, and we are saying that this action by that particular body or authority is in excess of the powers that were given to them, it is in excess of the scope of the authorities, an action can be brought at the Supreme Court for the Supreme Court's exclusive original jurisdiction to be invoked to deal with that. And we have a case that supports such a proposition or such a constitutional position. Now, this case was in the valedictory judgment that was given by Justice Sophia Adinyira, okay, Justice Adinyira, in the case of Center for Juvenile Delinquency versus the Ghana Revenue Authority and the Attorney General. This was reported in the 2019 Supreme Court of Ghana Law Reports. Like I said, incidentally, that was Justice Adinyira's final judgment when she left the bench at the Supreme Court. What were the facts that were pursuant to this particular case? Now, you see, in the Revenue Administration Act, that is the act of parliament that sought to see or regulate how monies that are, or taxpayers' money are collected or administered. That was Act 915. There was a certain provision in the second schedule of the Revenue Administration Act when it was enacted in 2015. Now, the provision in there, in one of the sections in the second schedule, was that if someone was bringing a matter to the courts, okay, he had to endorse on his writ his TIN number, his tax identification number, before his matter could be heard in court, such that if someone had an issue and he wanted to come to court and he was not a registered taxpayer, he could not just go and take out a writ out of the registry of the court and bring an action to the court. So Center for Juvenile Delinquency and an NGO felt that no, this particular position, that this particular enactment by Parliament was inconsistent with the Constitution. It was in excess of the scope of authority that the Constitution actually granted Parliament to do. Also in respect to the kind of principles that Parliament ought to work with relative to justice and etc. So they brought an action seeking to invoke the Supreme Court's original jurisdiction under Article 130. Now, Justice Adinyira, Justice of the Supreme Court, Sophia, at the time, speaking for the Supreme Court, held that true. The right to justice is an inalienable right guaranteed to every citizen here in Ghana. All right? So if people are suffering any kind of grievances or injustice, they had the right to go to court. And therefore, when Parliament has passed an enactment, and the purpose of the enactment is to restrict people's access to the court, the learned justices of the Supreme Court were of the view that that amounted to an exercise that was in excess of their authority. And it also amounted to placing an undue fetter on the right to justice. The Supreme Court properly therefore held that its original jurisdiction has been properly invoked and therefore struck out that particular aspect of the Revenue Administration Act as unconstitutional. So further from 2015 to now, it has ceased to be a requirement by that particular Act of Parliament initially that if someone has a matter that he wants to bring to court, he needs to endorse upon his writ his tax identification number. It has ceased to be in such holdings. You understand that? So this is what we mean by the Supreme Court's original jurisdiction also being invoked when there's an allegation that an authority has done something that is in excess of the powers that were given it. It may be Parliament, it may be any other adjudicatory body. A person can seek to grant the action under Article 131 of the Constitution, and the Supreme Court's original jurisdiction can be properly invoked. Hope that is clear. All right. Let's move on finally to Article 132, Clause 2 of the Article 130 to see also the Supreme Court's exclusive original jurisdiction, how it may also manifest itself. Clause 2. Where an issue that relates to a matter or question referred to in Clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay proceedings and refer the question of law involved to the Supreme Court for determination. And the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court. Are we okay with that? Clear? So you see, of all the points that we've discussed under Article 130, Clause 1, I mean, the Supreme Court's exclusive original jurisdiction, how it manifests itself in the fact that maybe there will be aspects of interpretation and all that, all those things that we've discussed under Clause 1. Clause 2 is just saying that if any of all those troubles or questions arises in any court apart from the Supreme Court, and it is a matter of law, that court has to stay proceedings and have that matter brought to the Supreme Court for determination. When the Supreme Court answers those constitutional matters, they will bring it back to the court, and the court will go ahead with the disposition of the case. Our case law in Ghana is replete of so many. It's an everyday occurrence. It happens a lot, where matters that are being held in the circuit courts, in the high courts, even in the district courts, it raises some matters of constitutionality, and the courts have to stay proceedings. Staying proceedings means that they hold on with whatever matter that is there, refer the matter to the Supreme Court to have the Supreme Court determine the questions of law that have predicated on interpretation of the Constitution or its enforcement or any of those articles. When the Supreme Court is done with this work, the Supreme Court will refer the matter back to the particular court, and the court will dispose of the matter. It's very simple. There are so many cases. We'll just talk about one of them. I'm sure you might have heard of the famous case Titi Nate versus Godwin Gatti. Okay, that matter gave us an opportunity for the Supreme Court to explain Article 17 of the Constitution, that is, all persons are equal before the law. Now, this is where some of the backgrounds to the case. Titi Nate was a lawyer. He represented one man who was Godwin Gatti in a particular case where Gatti had wanted to claim compensation for some accident that he had suffered due to the negligence of a driver. Now, after he had helped him to seek the compensation, of course, by representing him as a lawyer, he made demands for his retention, the amount of money that Godwin Gatti had to pay to him as the lawyer. And he gave him a certain kind of ultimatum by writing a letter to him to tell him that he needed his money forthwith. Then Titi Nate said that no, Godwin Gatti was a bit reluctant, so Titi Nate brought an action at the district court. The lawyer brought an action against the client, seeking to kind of take the money from him. And the decision, or the how do you call it? The position of the defendant, Gatti, at the time was that he needed some time to try and put things together. Okay? Now, when you look at the Legal Professions Act, it says that if a lawyer wants to, for example, exact amounts or money due him from a client, the provisions were to the effect that he had to give him at least 1 month's notice, okay, said that the client would be able to prepare himself or whatever and give him his money. Now, Titi Nate was of the view that this particular provision in the Legal Professions Act was unconstitutional. Okay, it was unconstitutional because it flouted the constitutional provision of every person is equal before the law. So why is it that, as for me, only as a lawyer, if I have to take money from somebody, I need to give him 1 month's notice? So he felt that that particular provision there was inconsistent with the Constitution, which says that everybody is equal before the law. Had it not been the fact that he was a lawyer, would Gatti have been able to invoke that particular clause that give me notice before? No. So why should it be me as a lawyer? I mean, we are all equal before the law. You understand his reasoning. All right, this matter was held in the district court, but his worship, Ali Baturi, saw that it raises some particular constitutional matters. Why? Because we then have to determine whether the constitutional article and Article 17, which says that all persons are equal before the law, implied that what was within the Legal Professions Act amounted to a discrimination against lawyers. So the matter was stayed and it went to the Supreme Court. And it gave the Supreme Court to at least give Ghanaians a clarity on the real ambit and scope of Article 17 as to what we mean by all persons are equal before the law. And it was a stellar judgment in the Supreme Court by Justice Samuel Datiba. You should read it. So you see, this Titi Nate versus Godwin Gatti's case illustrates what we mean under Article 130 Clause 2, that when matters of the Constitutions, be it its enforcement or be its interpretation, arises in any other court, the court has to stay proceedings, refer the matter to the Supreme Court to deal with it, then they will revert it back to the court for the court to handle. Hope you understand that. All right, so basically this is what we mean, or this is where we bring the curtain down onto our discussion of the Supreme Court's exclusive original jurisdiction under Article 130. By way of review, we are saying that the Supreme Court's exclusive original jurisdiction means that the power or the jurisdiction of the Supreme Court to hear certain matters for the very first time, or the Supreme Court to be the court of first instance, you will not take that matter anywhere apart from the Supreme Court. That is what we mean by the Supreme Court's exclusive original jurisdiction. And we are saying that that will happen if it borders on an interpretation of a provision of the Constitution. And under the interpretation, we've mentioned that if it is contentious, if it's ambiguous, or it's imprecise, or there are rival decisions or positions being put on by the parties, said that we are not quite clear as to what the constitutional provision is, or what the constitutional position is, the Supreme Court would be the best forum for that matter to be held. Okay? And also, if it also involves an enforcement of any part of the Constitution, the Supreme Court will have that. And we are saying that it is exclusive. It is exclusive because apart from the Supreme Court, no court in Ghana will have the right to do that. But when it comes to human rights matters, and a person's human right is being infringed upon, that person has to go to the High Court for that matter to be held. That is what we mean by subject to the High Court's jurisdiction for the enforcement of fundamental human rights. However, by the Samuel Boateng case, if the kind of breach of the human right that is being complained of is public in nature, public in character, it affects the wider Ghanaian public, such that it does not just become just a personal matter, then the Supreme Court, even though it is a human rights issue, an action could be brought to the Supreme Court. Why? Because it is in the interest of the public. Beyond that, any other human rights matter cannot be disguised as a constitutional matter and brought before the Supreme Court. The Supreme Court will throw it away. And there are several cases that illustrate that particular part. All right? All right. So that is fine. That is what we mean by the exclusive original jurisdiction. And we've mentioned, if there are also enactments or actions by bodies that infringes on that, the Supreme Court will have its jurisdiction being invoked. And finally, if any other court, district, circuit, high court, any adjudicatory body, or any matter anywhere within any court, if a matter arises and it hinges on a point of law in the Constitution, that court has to stay proceedings. Hold on with whatever that they are saying. Refer the matter to the Supreme Court. The Supreme Court will hear that matter, and whatever constitutional conclusions that they come to, the matter will be reverted back to the court for the court to proceed with that. That is what we mean by the Supreme Court's jurisdiction under Article 130. Hope you are fine. All right, stay tuned as you also discuss Part 3, where we talk about the Supreme Court's jurisdiction when it refers to this supervisory and review jurisdiction.